In California, there's a number of ways that trustees can escape liability. So even if they cause damage to your trust, you have to be careful because a trustee can still be let off the hook. The first issue is statutes of limitation. So if you've been given any type of written report about what the trustee has done, or you've been given a written accounting that discloses what the trustee has done, you only have 3 years within which to bring any type of objection in court in order to hold that trustee accountable. If you sit on your hands and you sit on your rights and you don't bring an objection in court, then after 3 years you are forever barred from objecting to that trustee's actions. The next way that a trustee can be let off the hook is through consents and releases. And this is where a beneficiary voluntarily, by signing a piece of paper, can let the trustee off the hook. With a consent, a beneficiary will agree and accept what a trustee is going to do in the future before the trustee actually takes that action. And if a beneficiary signs a consent saying that they consent to the trustee's proposed actions, then the beneficiary cannot come back later and contest the trustee's actions. They cannot complain about it because they already provided their consent ahead of time. The same is true for a release, except that a release typically comes after the action has been taken. So if a trustee were to sell a piece of real property for a certain price that the beneficiary doesn't agree to, but the beneficiary then releases the trustee from liability for that, then the beneficiary cannot come back later and try to sue that trustee because they have released the trustee from liability. The next way that a trustee can be let off the hook is with an exculpation clause. Our California probate code allows a settlor to put a clause in a trust that says the trustee cannot be held liable to the beneficiaries even if that trustee causes damage. And that's what an exculpation clause is it limits the trustee's liability. It prevents the beneficiary from holding the trustee accountable. Now there are exceptions to exculpation. The trustee can still be held liable if the beneficiary proves that the trustee acted with gross negligence, recklessness, or intentionally. But that's a higher standard than what is normally used in a trustee case. And so an exculpation clause can be a very difficult clause to overcome, and you have to look closely at your trust document to see if an exculpation clause exists. And the final way that a trustee can be let off the hook is through the use of equity. Under our California probate code, it gives the probate court the discretion to let a trustee off the hook if the court feels that it would be fair to do so under the circumstances. Now, as you can imagine, that's a wide open standard. What does it mean if something's fair under the circumstances? That's for the court to decide, and it's going to be different in every case based on the facts and circumstances of every case. So what that means to you as a beneficiary is heading into court, you really have to think about what is the story that you can tell the court as to why what the trustee did is not fair under the circumstances. You need to be able to present your side of the case in a way where the equities favor you and not the trustee.